Labor Laws Lecture Overview. Labor legislations, contract, appointment, working hours and conditions, leaves and holidays, children, employment, labor disputes, equal employment practices in Pakistan. Labor laws. The Constitution of Pakistan, Part 2, Fundamental Rights and Principles of Policy. Article 11 of the Constitution prohibits all forms of slavery, forced labor and child labor. Article 17 provides for a fundamental right to exercise the freedom of association and the right to form unions. Article 18 gives the right to its citizens to enter upon any lawful profession or occupation and to conduct any lawful trade or business. Article 25 addresses the right to equality before the law and prohibition of discrimination on the grounds of sex alone. Labor laws. Article 37E makes provision for securing just and humane conditions of work, ensuring that children and women are not employed in vocations unsuited to their age or sex, and for maternity benefits for women in employment. Labor legislation. Industrial and Commercial Employment Standing Orders Ordinance was enacted in 1968 addressing the relationship between employer and employee and the contract of employment. The ordinance applies to all industrial and commercial establishments throughout the country employing 20 or more workers. Every employer in an industrial or commercial establishment is required to issue a formal appointment letter at the time of employment containing nature of job, tenure of appointment, pay and allowances, working hours, terms and conditions of appointment. Labor laws. Termination of appointment must be communicated in writing. Under Section 46 of the Industrial Relations Ordinance 2002, aggrieved employee may proceed him or herself or through labor union within 3 months. Labor courts examines and intervene a case of violation of principle of nature of justice and unjust action of the employer. The Factories Act, which governs the conditions of work of industrial labor, applies to factories employing 10 or more workers. Under the Factories Act 1934, no adult employee, defined as a worker who has completed his or her 18th year of age, can be required or permitted to work in any establishment in excess of 9 hours a day and 48 hours a week. Section 8 of the West Pakistan Shops and Establishments Ordinance, 1969, restricts weekly work hours at 48 hours. Labor laws. Section 22B of the Mines Act, 1923 restrict weekly hours at 48 hours or 8 hours each day, with the limitation of spread over 12 hours and interval for rest for 1 hour every 6 hours. Section 22C further limits the spread over to 8 hours for work done below ground level. The Factory Act enforces that no worker shall be required to work continuously for more than 6 hours. According to the Factories Act 1934, every worker who has completed a period of 12 months of continuous service in a factory shall be allowed holidays for 14 consecutive days. If he fails to avail whole leaves, the part of unavailed leave will be carried forward in next year. The Maternity Benefit Ordinance, 1958 stipulates that upon the completion of 4 months employment or qualifying period, a worker may have up to 6 weeks parental and postnatal leave with pay. Labor laws. The Factories Act, 1934 provides that every worker is entitled to 10 days casual leave with full pay and further 16 days sick or medical leave on half pay. Labor laws. Under Section 49 of the Factories Act, workers are entitled to enjoy gazetted holidays. If worker is required to work on holiday, he or she will be allowed substitute holiday on full pay. The Maternity Benefit Ordinance, 1958 prohibits the dismissal of the woman during her maternity leave. Mines Maternity Benefit Act, 1941 is applicable to women employed in the mines in Pakistan. Labor laws. Article 11.3 of Constitution of Pakistan prohibits the employment of children below the age of 14 years in any factory, mine or other hazardous employment. Make it obligatory to provide safe and human working conditions. The Factory Act provides that no child or adolescent is allowed to work in a factory between 7 p.m. and 6 a.m. Further laws emphasize on cleanliness, drainage, ventilation, and hygiene of workplace. Provision of drinking water. All passages, Stairs, entrance and exits points must be open and properly lighted to ensure safety. Article 38 of the Constitution speaks achieving equality in the form of securing the well-being of the people, irrespective of sex, caste, or race. Employment of children rules, 1995 Labor Laws. The Payment of Wages Act, 1936 regulates payment of certain classes of industrial workers. The Act enforces payment of wages within 7 days if number of employees workers are less than 1,000, in other case within 10 days of completion of wage period. Article 24 of Industrial Relations Ordinance, 2002 make it compulsory to form joint works council for representation of workers in enterprise in establishment having 50 persons or more. The Joint Works Council deals with issues of settlement of differences through bilateral negotiations, promoting conditions of safety and health for the workers, encouraging vocational training within the establishment, taking measures for facilitating good and harmonious working conditions in the establishment, provision of educational facilities for children of workers. Freedom of association, Article 17 of the Constitution of Pakistan allow every citizen the right to form associations or unions. Labor laws. Registration of trade union is to be made under the Industrial Relations Ordinance. Labor disputes. Under Article 46 of the IRO 2002, a worker can bring his or her grievance to the notice of employer in writing within 1 month. If cause of such grievance, an employer within 15 days has to communicate the decision in writing to employee. If worker is dissatisfied with the decision or employer failed to communicate the decision in writing, employee can take the case to labor court within 2 months. Labor courts. Under Section 44 of the IRO 2002, provincial government can establish as many labor courts as it consider necessary. Of the ordinance, labor laws, collective bargaining agent and agreement. Industrial Relations Ordinance have provision for appointment of collective bargaining agent that is elected by secret ballot. CBA entitled to undertake collective bargaining with employers. CBA formulate collective agreements. Agreement may contain matters such as facilities for unions, dispute resolution process including grievance handling and disciplinary cases, settle terms and conditions of employment, wages, working hours, pension and retirement schemes, layoff, leave, level of job performance, etc. Agreement becomes source of law and used to settle disputes, so it must be drafted carefully. Labor laws, collective labor disputes. If the parties do not manage to reach a settlement, the employer or the CBA may, within 15 further days, serve a notice of conciliation on the other party, with a copy to the conciliator and to the labor court. If the dispute is settled before the conciliator, or a tripartite board of conciliators, a report is sent to the provincial or federal government, with a memorandum of settlement. Labor laws, collective labor disputes. If the conciliation fails, the conciliator tries to persuade the parties to refer their dispute to an arbitrator. If they agree, the parties make a joint request in writing to the arbitrator they have agreed upon. The arbitrator gives his or her award within a period of 30 days or a period agreed upon by the parties. The award of the arbitrator is final and valid for a period not exceeding 2 years. Labor laws. Proceedings of strikes and lockouts. If dispute settlement proceedings before the conciliator fail and no settlement is reached, and if the parties have not agreed to refer their dispute to an arbitrator, the workers retain the right under Section 31 of the Industrial Relations Ordinance 2002 to go on strike providing due notice to their employer within 7 days, and the employer has the right to declare a lockout after the delay of notice of conciliation has expired. Where a strike or lockout lasts for more than 15 days, if it relates to a dispute which the Commission is competent to adjudicate and determine, the federal and/or the provincial government may, by order in writing, prohibit the strike or lockout at any time before the expiry of 30 days, provided that the continuance of such a strike or lockout causes serious hardship to the community or is prejudicial to the national interest. Labor laws proceedings of strikes and lockouts. If under Section 32 of the IRO 2002, if a strike or lockout occurs within the public utility services sector, the federal government and the provincial government may, by order in writing, also prohibit its occurrence at any time before or after the commencement of the strike or lockout. No party to an industrial dispute may go on strike or declare a lockout during the course of conciliation or arbitration proceedings, or while proceedings are pending before the labor court. A strike or lockout is declared illegal if it is commenced without giving notice of conciliation to the other party of the dispute, or if it is commenced or continued in a manner other than that provided by the IRO 2002. In case of an illegal strike or lockout, an officer from the Labor Department may make a report to the Labor Court and require the employer, CBA, or the registered trade union concerned to appear before the court. The court may, within 10 days, order the strike or lockout to be stopped. Labor laws proceedings of strikes and lockouts. If, in case of contravention of the order of the court by the employer, and if the court is satisfied that the pursuance of the lockout is causing serious hardship to the community or is prejudicial to the national interest, it may order the attachment of the factory and the appointment of an official receiver who will exercise the powers of management and may do all such acts as are necessary for conducting business. In case of contravention of the order of the court by the workers, the labor court may pass orders of dismissal against the striking workers, or cancel the registration of the trade union that committed such contravention.